Hello everyone, my name is Ahmad Naufal. I from Banjarmasin, Kalimantan Selatan, and I'm currently an undergraduate law student in Class A at Universitas Negeri Yogyakarta. My academic focus revolves around constitutional and civil law, where I frequently employ empirical juridical approach to analyze contemporary legal issues. Mastering English is essential for my academic and professional development. It allows me to conduct comparative research, access international legal frameworks, and engage in cross-jurisdictional analysis. These skills are fundamentally crucial for my future career goal of becoming a university lecturer, specializing in constitutional law. For today's presentation, I will analyze a recent article published by the Jakarta Post on June 9, 2026, titled Breaking House Passes New Police Law in Rush Process. The report detailed the Indonesian House of Representatives sweep and highly controversial passage of an amendment to the 2002 police law during a plenary session in Jakarta. Driven by a fast-track legislative initiative, this revision fundamentally alters the landscape of law enforcement by introducing Article 28A. This specific article explicitly expands the authority of the active duty police officer, allowing them to occupy civilian bureaucratic positions across various government ministries and state agencies without requiring early retirement. Proponents of the bills argue that this change is necessary to adapt to modern governments and security needs. However, the how and why behind the passing of this legislation have become the center of massive public scrutiny. The legislative development was executed with unprecedented speed, sparking immediate and intense criticisms from various civil society organizations and legal watchdogs. They argue that the expedite approval process intentionally bypassed the constitutional mandate for meaningful public participation. Furthermore, the new highlights that the discussions surrounding the bill were largely held behind closed doors, minimizing opportunities for academic debate and societal input. The primary legal issue in this case is the potential jurisdictional overlap between civilian governance and the law enforcement apparatus. The core legal instruments involved are the newly amended 2002 Police Law, specifically in Article 28A and Constitutional Court Decision Number 114 of 2025. In my legal opinion, this amendment requires strict constitutional scrutiny. The legal consequences of the implementing Article 20A directly threaten to blur the established boundaries between civilians' bureaucratic domain and police institution, potentially disrupting the checks and balances within the state administration. Furthermore, based on field observation of the social dynamic, the widespread public resistance to this legislative change represents a cultural obstacle rooted in collective historical memory of society regarding dual function practice. It is essential to recognize that this resistance is fundamentally cultural rather than a structural or systemic failure of the community. The main lesson learned from this case is that the formulation of positive law must systemically harmonize with constitutional supremacy and carefully address the cultural realities of the society. To conclude, the recent amendment to the 2002 police law is far more than a mere administrative shift. It is a profound constitutional issue that demands our continuous critical attention. As law students and future legal scholars, it is our inherent duty to ensure that any legislative development strictly uphold the principle of the transparency, the system of checks and balances, and ultimately the supremacy of the Constitution. Thank you everyone for tuning in to my legal analysis presentation. Stay critical, uphold the law, and have a wonderful day.